the Atlantic Philanthropies, who are hosting this event and also in their beautiful space, and also make possible through their support so much of the work we do on liberty and national security, including the work of our chief counsel, who you'll hear from, Fritz Schwartz, who is also chair of the Atlantic Board, as well as others, the Open Society Foundations, the Democracy Alliance Partners, and the Herb Block Foundation, and many others who support our work on this issue. And for those of you who don't know, the Brennan Center for Justice is a nonpartisan law and policy institute that focuses on fundamental issues of democracy and justice. And we were named after Justice William Brennan, started by his clerks and family. And we take our spirit from Justice Brennan when he said that the genius of the Constitution rests not in any static meaning it might have had in a world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs. That spirit animates our work, and that vision is especially vital in the fight to protect America against terrorism. We gather here today, as many of you know, 1 mile from Ground Zero, that way. And we're 3 miles from Times Square, that way. 1 mile from the home of the worst act of terrorism against the United States, and 3 miles from a place that reminded us that terrorism remains a real threat, that new kinds of terrorism, homegrown terrorism, poses new threats. We all have a duty, and those who are here who work on it every day know this very well. We all have a duty to protect the country and protect the people from violence. And at the same time, we all have a duty to do so in a way that is effective, that honors our values and respects our Constitution, our freedom of religion, and our pluralism that makes America what it is. Hence the challenges, and hence this conference. Now, when our Liberty and National Security program began 7 years ago, it really focused, as so many people did in the immediate aftermath of September 11th, on issues around the world, on the issues of detention, and especially from our perspective on making sure that checks and balances, the core constitutional structure, were followed. But we, as so many, recognized that the fight against homegrown terror, the new challenges of domestic counterterrorism, are in so many ways the newest and most critical issues we face as people who care about security and who care about civil liberties. In the last 2 months, we released 2 significant reports on this topic. One dealing with and critiquing the FBI guidelines, the so-called Mukasey guidelines that were adopted dealing with FBI investigative powers, and most recently a report on rethinking radicalization. Both of these are available for anybody who's interested who doesn't have them. And these are the types of work we do, nonpartisan, fact-based, and we hope contributing to the dialogue. And of course, in the world after September 11th, we are all calling on law enforcement to do something new, something different from what it is accustomed to doing in many ways. Law enforcement are no longer charged merely with fighting crime, but with preventing crime, with gathering intelligence, with weaving the community together in a way that gathers intelligence, with gathering as much information as possible to make sure that we know what's happening and to make sure that the worst doesn't happen. This is a complex challenge. This is not easy, and there are really difficult issues that we all have to grapple with together. How to do this in the most effective way, how to make sure that the information being relied upon is valid information, how to make sure that core protections of, say, freedom of religion are reflected, and how to make sure, among other things, that the very communities whose cooperation has proven so vital in the fight against terrorism to date are not pushed away by the very policies seeking to protect the country. These and many other issues so many of you deal with every day, and we believed that it was important to bring together people from different communities, different perspectives, different professional backgrounds, to talk about them, to find, we hope, some common ground, and certainly to expose the issues to the broader country. I should mention to you that this conference is being videotaped and we hope live streamed. Oh, I get thumbs up. So it is being live streamed. So you all will be able to convey your thoughts to the wider world, we hope. We bring your colleagues here today are law enforcement professionals, intelligence professionals, community leaders, civil libertarians, and some of the top academic experts in the country. And we are, again, really delighted to gather and to welcome you. And we are very lucky to hear first from two remarkably distinguished national leaders in this effort who deal with these issues every day in their own work. First, we will be lucky and privileged to hear from Congressman Bennie Thompson. Congressman Thompson has represented Mississippi's 2nd Congressional District since 1993. He served as the first Democratic chairman of the Homeland Security Committee. He was responsible, among many other things, for passage of H.R. 1, the 9/11 Commission's Recommendation Act of 2007, and those of us who've worked in Washington know that getting H.R. 1 as the designation, if nothing else, is a major intelligence coup. But it was a very important piece of legislation. He has been a powerful voice for social justice throughout his career and in this complex set of issues. And currently he is the ranking member of the Homeland Security Committee. And we all know, and the whole country heard last week, his powerful and passionate voice at the King hearings on radicalization, speaking out against stereotyping of any of our fellow Americans. And we are grateful for your leadership, for that voice, and we appreciate your being here today, Congressman Thompson.
Thank you very much, Michael. I'm happy to be here in New York at the Brennan Center. Happy to see John here too and others. When I received the invitation, I didn't know we would have coordinated a hearing in Washington that was so on point for the presentation. But it's, I think, interesting to note that those of you who saw it kind of see what we do in Washington, sometime good, sometime bad, but it's the process. And it's the process where differences meet, conflict, but at the end of the day, it's still the best country that I know anywhere in the world, and we have to actually get it right. And so I'm one of those individuals who has been on the Homeland Security Committee ever since it was a select committee when it was created. A select committee, for those of you who are here, is a committee with no jurisdiction. So you say, why in the world would you want to be on a committee with no jurisdiction, no authority in law? Well, if you can see the future, you understand Homeland Security would be important. Some of us saw the future and got on the committee and labored in the vineyard until we received authority and jurisdiction. We're still trying to consolidate the jurisdiction. We're kind of split between several other committees, but basically the buck starts with the Homeland Security Committee. The only other anecdotal comment I'd like to make before I go through my prepared presentation is I'm a product of the South. So much of my framework for work on the committee comes from being a student at Tougaloo College. I met Martin Luther King Jr. On the college campus, a lot of other people, and I found out that because I was in the meeting, my state government decided to spy on me because I was somehow one of those radicals who dared talk about the Constitution and freedom and equality in the state of Mississippi. And one of the good things is when I finally got to Washington, I had an opportunity to see my entire file, and so I saw a lot. My government is good at keeping up with it. But that also leads me to say that sometimes we spend a lot of money on unnecessary things. Me being at an ACLU meeting does not mirror or require the amount of expenditure of public resources all you can ask for is the minutes of the meeting, and you can get them. So it's not a big deal. But nonetheless, I'm happy to be here. And I want to thank the Brennan Center for the invitation. I'd like to acknowledge Faiza Patel's and the Brennan Center report on rethinking radicalization. Radicalization, recruitment, and violent extremism is an issue that my colleagues and I in Congress have dealt with for several years. The ideology of what actually drives an individual of any race or ethnicity to commit violent acts are very complex issues that both the legislative and executive branches are still grappling to comprehend. I'm sure many of you followed the committee hearing on radicalization and the American Muslim community. As you know, I wholeheartedly disagreed with the premise of the hearing and requested Chairman King to broaden the hearing scope. You see, as a member of Congress, I took an oath to support and defend the Constitution of the United States. And from my understanding, the First Amendment of the Constitution protects the freedom of religion and freedom of speech. This hearing overstepped those bounds and made law-abiding Americans unnecessarily uncomfortable. In addition to the hearing overstepping the bounds of the Constitution, an inquisition into the Muslim community ignored the facts that the Brennan Center's report reiterated. Violent extremism knows no race, religion, or ethnicity. As ranking member and former chairman of the Committee on Homeland Security, I take threats to our nation's safety and security very seriously. I firmly believe that an inquiry into extreme ideology and violent action should be a broad-based examination. I agree that homegrown terrorism and the jihadist threat deserves continuing attention. However, narrowly focusing our attention on a particular religious or ethnic group lacks clarity and common sense. Today's terrorists do not share a particular ethnic, educational, or socioeconomic background. Recently, when state law enforcement agencies were asked to identify terrorist groups in their states, Muslim extremists ranked 11th on a list of 18. Further, according to a study conducted by the Institute for Homeland Security Solutions, only 40 out of 86 terrorist cases examined from 1999 to 2009 had links to Al-Qaeda. According to the Southern Poverty Law Center, in 2010, the number of active hate groups in the United States topped 1,000 for the first time, and the anti-government movement expanded dramatically for the second straight year. This study indicated that several factors, including resentment over the changing racial demographics of the country, frustration over the lagging economy, and the mainstreaming of conspiracy theories contributed to the rise in the anti-government movement. Law enforcement agencies identified neo-Nazis, environmental extremists, and anti-tax groups as more prevalent and dangerous than Muslim terrorist organizations. The sophisticated explosive device found recently along a parade route in Washington on Martin Luther King Day, an act of domestic terrorism clearly motivated by racist ideology, should prove that other groups are just as willing and able to carry out horrific attacks on Americans. In addition, terrorist groups are not the only threat. According to the Department of Homeland Security, lone wolves and small terrorist cells may be the single most dangerous threat we face. Attacks are just as likely to come from lone wolf extremists like James Winnaker von Braun, the Holocaust Memorial Museum shooter, or Jared Lee Lochner, who is charged with a tragedy in Tucson, Arizona, as they are from Muslim extremist groups. And what do we do, and what do von Braun and Lochner have in common with Muslim Muslim extremists like Nadel Hassan, the Fort Hood shooter, and Colleen LaRose, also known as Jihad Jane, all allegedly espouse radical views on the internet through extremist websites, chat rooms, and popular websites. This starkly illustrates what should be common sense. The most effective means of identifying terrorists is through their behavior, not ethnicity, race, or religion. While knowing these facts put us at an advantage, just being aware is not enough. The nation's law enforcement resources have already stretched thin. Understand this. We must ensure that we are using these resources to yield the best results. One of your other presenters today actually was my witness at the hearing last week. Wonderful person, the sheriff of Los Angeles County. Sheriff Barker gets it. I think you'll be pleasantly, is he here? He's coming. Okay, well, trust me, if he makes it, you won't be disappointed. Many people thought, why would a Democrat pick a Republican witness as their witness for the hearing? Well, Sheriff Barker understands that you have to engage communities in order to receive intelligence as to what's going on, but you also have to instill confidence in the community that they won't be betrayed nor intimidated or outed if that intelligence is forthcoming. If you do it the other way, then the information necessary to secure our communities from any group will be lessened, and good law enforcement will dictate that you have to engage communities rather than intimidate communities. So I pay special tribute to Sheriff Barker and his men and women in uniform. But the other thing I'll confess to this group, and since we're being televised, members of Congress really don't know everything. Sometimes we pretend we do, but in reality, we depend on individuals like you to provide the research, the encouragement, the advocacy for your issues so that we get it right. This country is only as good as its people, and unless we continue to promote the involvement actively of all its people, we won't get it right. Lastly, I think we have to understand that whatever we do here has ramifications internationally. So if we start showing that we are picking on any particular group in America just because of who they are, then clearly there are other people in other parts of the world who will take advantage of that. So when we say on our committee, some of the conventional thought is that we ought to profile all Muslims. We can't do that. Or if someone says we have too many mosques in America, we can't promote that school of thought, because both schools of thought create opportunities for bad people to do mischief other places. Now, how can good people like you help us? Apart from what you do, we all have to be committed to making sure to help keeping this country safe. Unfortunately, we can invent every piece of technology known to man, and somehow bad things potentially will still happen. So people have to become involved in the process too. You say, well, what can I do? I'm just a lawyer trying to make a living, a research assistant or religious person. Well, all of us. The term we adopted last year was see something, say something. Very simple. You can help us. For a person from Mississippi to encourage people to participate in government and help us keep it safe is something I learned because I trust my government. I trust my federal government to get it right. I still got a few issues, state and local, but I'm working on them too. But I do trust my federal government to get it right. So, more or less, we have to maximize our efforts to counter violent extremism and radicalization in this country. If we're going to move forward, we have to recognize and protect this nation. Our Constitution is a sacred document. The First Amendment talks about individual thought and speech being protected. But under the Fourth Amendment, there's subsequent jurisprudence. Americans also enjoy significant privacy rights. I don't think Big Brother should be peeping in our bedrooms just because it's Big Brother or any other thing. There are ways that we can get intelligence without infringing on the rights of people, and I'm one of those individuals who promote it. I've encouraged our president to appoint the Privacy Oversight Civil Liberties Board. I've been promoting that since for 2 years now. We still don't have the board appointed. We sent another letter this week saying we have to do it. This is easy. Congress said do it, do it. But we haven't gotten there yet, so I will wait on my next opportunity to share it with the president. I appreciate the opportunity to come and talk a little bit. I'm told for questions, or do we want to do the next speaker and then do questions, or how do we want to do it, Michael?
I think we'll do questions for you, Congressman, and then
okay.
Director Brennan. So if folks have questions, please join in, and the microphones are on either side of the pillars right here. I'll get the ball started, but hope I'm not the only questioner. Congressman, last week's hearings were seen all around the world. Did you, after they were over, feel that they had a positive impact as well as a negative impact? What did you all learn, and what was the ramifications of the spectacle in a way?
Well, by the time the hearings actually commenced, given the volume of participation by the world community, we've moved the issue from just being perceived as a singularly focused hearing, because we brought it with others' help into a clearer focus. We actually introduced 32 exhibits, petitions, other things from religious, legal, and others, indicating some objections to what was going on. I'm convinced we accomplished it. The witnesses put on by the chairman did not really set the woods on fire from the standpoint of scholarly research, and that's an understatement. So I'm convinced that people now understand that you can't just single people out because of religion or anything else. Now, unfortunately, there's talk of another hearing dealing with radicalization of the Muslim community in prisons. And if it materializes, I think people are going to have to get engaged again, because there's also proof that there are some other individuals in prisons who are far more dangerous than individuals who perhaps are Muslim. And we're trying to keep Peter on the straight and narrow, but it's a full-time job.
You're next, and then you.
Representative Thompson, thanks so much for your leadership on the committee and on these hearings in particular. And you've addressed certainly many of the civil rights concerns and the constitutional rights concerns that emerge from the new McCarthyism. I'm curious if you can shed any light on the national security implications of demonizing communities, to the extent, if it's an international battle for the hearts and minds, or whether it's an effort to gain the trust and engagement of communities to gain access to human intelligence, or if it's simply preventing radicalization by avoiding alienating people further. If you have any thoughts on the ways where it makes
I kind of alluded to the world picture that, as Michael indicated, the whole world was looking at the hearings, and you want to be very careful that in hearings you don't alienate people or somehow decide to mischaracterize people because of their faith. We tried to tamp that down so that individuals watching could not really take full advantage of it, and I think we made our point. But the other issue is that this whole notion of radicalization is one where so much of what we do becomes the discussion. And we have to be very careful. We can't be perceived just because we're United States that we can pick on individuals. And I think that we can be tough, we can be hard, but we need to be perceived as understanding and wanting to engage communities and not isolate communities in the process. And Sheriff Barker, he was being kind of singled out because of his relationship with a particular Muslim organization, and was told, well, the FBI said something about these people, and I don't understand why you dealing with them. Well, sheriff looked at him and said, look, I think if the FBI had a problem with it, they'd talk to me a lot faster than they'd talk to you, and they haven't said anything to me. So, I mean, but he gets it, and he's not going to be intimidated by the rhetoric that we hear coming from others.
Thank you.
I believe he was first. Yeah.
Could you please identify yourself before you speak? Sure. Thank you.
Hi, I'm Bart Gelman from Time. I wonder if you could say a little more specifically some of the ways in which you think the FBI has either obtained too many powers or its practices have gone too far.
Well, they have part of the domestic mission, as you know, here. And I think a lot of us who had earlier experience with the Hoover policies say that our government should operate within the parameters of the law. And in some instances, I think that was disproven, and in some instances, especially during the civil rights era, we even created more problems than we resolved in some communities. One of the challenges we still have is how do we get the intelligence gathering communities to talk to each other and share information. We've passed legislation that say they should do this, but the stovepiping still exists within the different communities, even though some people say it doesn't, but it's still there. unfortunately, in some instances, the need to know reference is still around. And I have participated in a number of briefings of various levels, and I still leave there feeling like I didn't quite get it all. And as a member of Congress, I think I should be exposed to all the information available, but it's still not there. And we've put institutions together. I'm trying to be kind of nice about it, but we still have challenges. Let me say that. The men and women do a good job, but advocates have to stay vigilant to make sure that everyone stays in their lane. And the oversight by the various committees is important, but the oversight by the public at large is important. We have various legal methods that if you want to do certain things from an intelligence gathering standpoint, you can do it. I think you have to stay in those lanes and not veer away from them. And sometimes we've not done that.
We have time for one more question for the Congressman.
Hi, my name is Megan Keneally. I'm from the New York Observer. I was wondering if you could characterize your relationship with Congressman King.
Actually, Peter and I get along very good. We just differ. Our committee historically has a reputation on the Hill for being one of the more agreeable committees. Most of the legislation we've passed has been overwhelmingly bipartisan. The hearings is another thing, as you know. But at the end of the day, I'm convinced that that relationship is good. Peter and I have been on the committee from day one, and he's been chair, I've been chair, now he's chair again. And so we have what I think is a good relationship. His Irish accent kind of overrides my Southern accent, but beyond that, it's all right. He's Peter.
Thank you so much, Congressman, for displaying diplomacy as well as leadership. We appreciate it. We appreciate all you do. And again, thank you for being here. And now we continue the morning's program. And again, we are very lucky to have with us John Brennan. Time Magazine's fascinating profile of Mr. Brennan, as you may have seen a few weeks ago, bore the portentous headline, Obama's counterterrorism czar comes out from the shadows. And on this very sunshiny day, we hope we can at least bring a little more light and out of the shadows. And we are deeply grateful to you for being here and for all you do. John Brennan has served as Assistant to the President for Homeland Security and Counterterrorism since President Obama took office in January of 2009. He serves as Homeland Security Advisor and as Deputy National Security Advisor for Counterterrorism. Mr. Brennan has a distinguished 25-year career with the Central Intelligence Agency, serving in a variety of senior positions. He is the recipient of numerous awards and commendations for his work protecting the country and keeping us safe, including the National Security Medal and the Distinguished Intelligence Medal and other commendations as well. I encourage you to read the article to get a sense of the intensity of the effort required day in and day out to protect us, and we are doubly grateful, therefore, that you were able to make the time to be with us today to share your thoughts. Ladies and gentlemen, please welcome John Brennan.
Thank you, Michael, for that very kind introduction, and thank you for your leadership here at the Brennan Center for Justice. And I must admit, I like the sound of that, the Brennan Center for Justice. And I'd also like to thank Congressman Thompson for your very eloquent and thoughtful remarks this morning. And I think it's particularly fitting that you remind us all at the beginning of today's events what it means to be an American and how un-American it is to single out groups because of their ethnic background, religious affiliation, or political association. And I think it was a very apt and poignant reminder to all of us here today. I'd like to thank the entire Brennan Center for this invitation, which I truly appreciate on a very personal level. As an Irish Catholic kid from New Jersey, the role models for my generation didn't come any better than Justice William Brennan, an Irish Catholic kid from New Jersey. And you can imagine my pride when I discovered that my family has its roots in the same part of Ireland as Justice Brennan's family, County Roscommon. And I've also often wondered whether, just maybe somewhere along the line, our families have shared roots. I may never know for sure, but I consider it an honor to speak here today at an institution that has done so much to keep his legacy very much alive. And Michael, as a veteran of the White House staff yourself, you know how hard it is to escape from the West Wing for discussions like these, which are a chance to step back and take a broader look at the pressing issues of the day. In recent weeks, the pace of world events has been dizzying indeed, from the historic events across the Middle East to the devastating earthquake and tsunami in Japan. But I very much wanted to join you here today to discuss a subject that I deal with directly every day and which is vital to our national security: the role of law enforcement in the post-9/11 era. And I want to take this opportunity to put that work in a broader context: the principles and policies that are guiding the President and his administration as we work to prevent acts of terrorism against the American people. Nearly 10 years after the September 11th terrorist attacks, the United States remains at war with al-Qaeda and its adherents. Because of the relentless pressure to which we've subjected it, the senior al-Qaeda leadership is increasingly hunkered down in its safe haven in Pakistan's tribal regions. Still, it retains the intent and capability to attack the U.S. homeland as well as our allies abroad. Despite having its ideology rejected by the overwhelming majority of Muslims and being at its weakest point since 2001, the threat from al-Qaeda is diversifying. Groups and individuals have sprung up in places like Pakistan, Yemen, and North Africa, and seek to commit violent acts to further al-Qaeda's murderous agenda. We have also seen this problem begin to manifest itself here at home. A very small but increasing number of individuals here in the United States have become captivated by these violent causes, seeking to commit violent acts here at home, their plots disrupted in Washington, D.C., Oregon, and Maryland during the past year alone. Others have traveled abroad to join the ranks of international terrorist groups and work to further their cause. Though it has changed significantly over the past 10 years, the threat from al-Qaeda and its adherents represent the preeminent counterterrorism challenge we face today, and protecting the American people from this threat remains our highest national security priority. Some suggest that this is largely a military and intelligence challenge with a military and intelligence solution. Our military and intelligence professionals and the unique capabilities they offer are an essential part of our counterterrorism efforts. But to argue that they are the only solution or that we should place limitations on other tools and capabilities is a misunderstanding of the complexity of the problem we face. Confronting this complex and constantly evolving threat does not lend itself to simple, straightforward solutions. No single tool alone is enough to protect the American people against this threat. We need to use all of these tools together, and that is what the Obama administration is doing. So our counterterrorism efforts are guided by several core principles. First, our highest priority is and always will be the safety and security of the American people. The United States government has no greater responsibility. Second, we will use every lawfully available tool at our disposal to keep the American people safe: military, intelligence, homeland security, law enforcement, diplomacy, and financial, at all levels of the government working seamlessly. Third, even as we are unyielding in pursuit of those who would do us harm, We will remain true to our values and ideals that have always defined us as a nation. Only by adhering to our values are we able to rally individuals, communities, and entire nations to the cause of protecting the world against the threat posed by Al-Qaeda. Fourth, we will be pragmatic, not ideological, making decisions not on the basis of preconceived notions of which tool is perceived to be stronger, but based on the evidence of what works, what will keep Americans safe. Fifth, we must retain the necessary flexibility to address each threat in a way that best serves our national security interests. When confronting the diverse and evolving threat from Al-Qaeda and its adherents, different circumstances will call for different tools. Just like when we have to face the threat posed by all types of terrorist organizations, we must apply the appropriate tools. Guided by these principles, the administration has worked hard over the past 2 years to establish a counterterrorism framework that is effective and sustainable. This includes the two tools you have gathered here today to discuss: law enforcement and intelligence. The intersection of these two has at times become a subject of intense debate. But to draw the conclusion that the use of law enforcement tools prior to 9/11 somehow hindered our efforts to protect the American people, and that we should therefore abandon the use of law enforcement in this conflict, would be a mistake. In the aftermath of 9/11, the challenges we had to overcome to effectively confront the terrorist threat to this country proved to be much more complicated than ever before. As a result, much of what we have seen over the past 10 years has been an evolution to find flexible and effective ways to leverage all of our capabilities to confront an evolving threat, including our law enforcement and our intelligence capabilities. Law enforcement and intelligence are not mutually exclusive. In fact, they can and must reinforce one another. Intelligence is absolutely critical to identifying and disrupting terrorist networks. It empowers law enforcement, informing their operations and enabling them to identify and disrupt plots before they are carried out. And intelligence often plays a critical role as evidence at criminal trials. Law enforcement is equally indispensable. Through aggressive investigations, we have been able to identify members of terrorist networks and detect their plots. The tools available to law enforcement allow us to swiftly disrupt the plots we uncover and to incapacitate dangerous individuals through successful prosecution and conviction. Law enforcement also has a well-proven track record of gathering vital intelligence through interrogation. When faced with the fair but heavy hand of American justice, terrorists have offered up valuable intelligence about Al-Qaeda and other terrorist groups. Our challenge, therefore, has been to carefully integrate intelligence and law enforcement, consistent with our values and rule of law, to ensure that they complement and reinforce each other. After 9/11, our law enforcement and intelligence communities had to adapt, gain new tools and authorities, restructure and change their cultures and operations. We've updated and improved our criminal code to better empower law enforcement to disrupt plots before they take innocent lives. We eliminated the so-called wall to allow intelligence and law enforcement personnel to work together, a critical step toward better integration of our law enforcement and intelligence tools, and to break down those stovepipes that Congressman Thompson addressed. The USA Patriot Act and amendments to the Foreign Intelligence Surveillance Act, or the FISA Act, provided our counterterrorism community with enhanced investigative authorities. We reorganized our intelligence, law enforcement, and counterterrorism communities to enable them to function more effectively as a whole. The Federal Bureau of Investigation has been further integrated into the intelligence community and continues its transformation into an intelligence-driven organization. Each of these steps has transformed law enforcement into a more effective counterterrorism tool, one that can be used preemptively, before an attack is attempted, before a bomb goes off. And because they remain bound by our laws and our Constitution, there will always be checks on the use of these law enforcement tools to ensure they remain consistent with our laws and with our values. As a result, today, we are better positioned to protect the American people. That does not mean that our work is done. When it comes to detention, interrogation, and prosecution of suspected terrorists, our record is clear. Spanning 2 consecutive administrations, we have successfully leveraged our criminal justice system to protect the American people against the threat from Al-Qaeda and other terrorist organizations and individuals. According to its own figures, the Bush administration used federal courts to prosecute suspected terrorists, including those apprehended overseas, on hundreds of occasions, including Zacarias Moussaoui, Richard Reed, Ahmed Omar, Abu Ali, Essanul Siddiqui, Osama Kassir, and many others. Today, this impressive record of arrest and prosecution of terrorist suspects in federal court is unfortunately frequently forgotten, which has prompted a debate over how best to handle, prosecute, and punish those accused of trying to attack our country. That debate has at times been conflated with another important and consequential debate that we are engaged in with respect to the future of Guantanamo. And nowhere does the intersection of law enforcement and intelligence, not to mention our Constitution and our values, come together as starkly as it does in Guantanamo. Before 2009, few counterterrorism proposals garnered as much support on both sides of the political aisle, from Colin Powell to President Bush and John McCain, as the proposal to close Guantanamo did. This administration, for the first time, consolidated all information about the detainees held there, and departments and agencies identified the most appropriate disposition for each individual and recommended that we bring several individuals to justice for their crimes. The administration remains committed to the closure of Guantanamo to do what is in the national security interests of this country. And we have continued to move forward with key elements of our plan, including restarting military commissions and providing those who will continue to be held a thorough process of periodic review to ensure their detention is necessary and is justified. But support for closing Guantanamo has inexplicably waned, and some in Congress have sought to impose unprecedented restrictions on the President's discretion to transfer and prosecute the individuals held there. Some have argued that all of these cases should be tried in military commissions and have sought to bar the executive branch from prosecuting any Guantanamo detainees in our Article III courts. Where we believe a military commission is appropriate, we will move forward. However, where the evidence suggests our federal courts are more likely to produce a result that is consistent with our national security, we will push Congress to repeal these restrictions so that we can take the steps necessary to bring those individuals to justice. Repeal of these unprecedented encroachments on executive authority is critical so that we can make informed decisions about where to bring terrorists to justice, transfer those it is no longer in our interest to detain, and achieve an essential national security objective, the closure of the detention center at Guantanamo Bay. Even as we deal responsibly with those in our custody, we face the challenge of dealing with those we capture or arrest in the future. When arresting terrorist suspects, we must balance at least 4 critical national security objectives. First, disrupt the terrorist-related activity of the individual, including ongoing plots to kill innocent people. Second, gather any intelligence the individual may have that could enable us to identify and disrupt additional plots against the United States and our allies. Third, protect the intelligence, including the sources and methods it comes from, that allowed us to identify or disrupt the individual as well as his or her activities. And finally, where the individual poses an enduring threat, as is often the case in terrorism investigations, provide for the sustainable incapacitation of that individual. There can at times be tension between these objectives, so our core principles and values must guide our every step. When confronted with the question of where to bring someone to justice, we cannot base our decisions on preconceived notions about which system is stronger or more effective in the abstract. The factual and legal complexities of each case and relative strength and weaknesses of each system must guide our decisions to ensure success. Otherwise, dangerous terrorists could be set free, intelligence lost, and lives put at risk. Terrorists arrested inside the United States will, as always, be processed exclusively through our criminal justice system. And let me say that again. Terrorists arrested inside the United States will be processed exclusively through our criminal justice system, as they should be. The alternative would be inconsistent with our values and our adherence to the rule of law. Our military does not patrol our streets or enforce our laws in this country, nor should it. Every single suspected terrorist taken into custody on American soil before and after the September 11th attacks has first been taken into custody by law enforcement. Our criminal justice system provides all of the authority and flexibility we need to effectively combat terrorist threats within our borders. In the aftermath of 9/11, 2 individuals taken into custody by law enforcement were later transferred to military custody, and after extensive litigation and significant cost, both were transferred back to law enforcement custody and prosecuted. Similarly, when it comes to U.S. citizens involved in terrorist-related activity, whether they are apprehended overseas or here at home, we will process them exclusively through our criminal justice system. There is bipartisan agreement that U.S. citizens should not be tried by military commission. Since 2001, two U.S. citizens were held in military custody, and after years of controversy and extensive litigation, one was released, the other was prosecuted in federal court. Even as the number of U.S. citizens arrested for terrorist-related activity has increased, our civilian courts have proven they are up to the job, providing all the flexibility and authority we need to counter the threat they pose. The United States cannot expect to detain its way out of this terrorism problem. Recreating another Guantanamo runs contrary to our national security interests. So we must work with our partners to empower them to assist us in our efforts to bring terrorists to justice. In many cases, their home country, the country in which they were apprehended, or the country they seek to attack, may have a similar interest to arrest and prosecute them. Where our partners have the capability to do so, we often work with those countries to assist them in those efforts by sharing evidence or making witnesses available to ensure that our collective interests are protected. Where countries lack the capability to lawfully detain and prosecute terrorists, we must work with them to develop those capabilities to mitigate the threat these individuals pose to their people and to ours. Our long-term security requires that they build and maintain the capacity to provide for their own security, to root out the al-Qaeda cancer that has manifested itself within their borders and to prevent it from returning. Where other countries are unwilling or unable to eliminate the threat an individual or network poses, we will continue to act, consistent with our legal obligations, to eliminate the threat. Where we take custody of an individual, we will maintain appropriate policies and mechanisms to preserve our ability to bring that individual to justice in our civilian courts and in our reformed military commissions. Our legal authority to use military commissions to prosecute terrorism suspects is not limited to Guantanamo, and we will not limit it to Guantanamo as a policy matter. We will reserve the right, where appropriate, to prosecute individuals we capture in the future abroad in reformed military commissions. Our federal courts are unrivaled when it comes to incapacitating dangerous terrorists. Since 2001, the Department of Justice has convicted hundreds of individuals in terrorism-related cases. In many of those cases, the individuals have received lengthy prison sentences and have provided significant and valuable intelligence. Law enforcement, including our federal courts, has been an indispensable part of our strategy to protect the American people, essential to efforts to disrupt, dismantle, and defeat al-Qaeda and its adherents. Where this option best protects the full range of U.S. security interests and the safety of the American people, we will not hesitate to use it. This is not a radical idea. As former Attorney General John Ashcroft said, our priority should be a priority of preventing future terrorist attacks. As he explained, to automatically allocate people from one system to another without understanding what best achieves that priority would be less than optimal. Now, some argue that military commissions are inherently more effective and therefore more appropriate for trying suspected terrorists. Yet our federal courts are time-tested, have resulted in far more detentions and convictions, and have produced much longer sentences on average than military commissions. In choosing between our federal courts and military commissions, in any given case, the administration will remain focused on producing the right result. Because of bipartisan efforts to ensure that military commissions provide all of the core protections that are necessary to ensure a fair trial, there are remarkable similarities between commissions and our federal courts. The reformed military commission system includes the attributes Americans believe are necessary to ensure a fair trial: presumption of innocence, proof beyond a reasonable doubt, an impartial decision maker, the right to counsel, including the right to choose your counsel, government-provided representation for those who cannot afford to pay, a right to be present during court proceedings, a right to exculpatory evidence, and a right to present evidence, compel witnesses, and compel favorable witness testimony. In 2009, Congress agreed to replace the original untested system for protecting classified information in military commission proceedings. They did so by largely codifying the rules that have proven extremely effective in our federal courts, a testament to the strength of our federal courts in protecting intelligence, and comfort that our commissions will do the same going forward. Now, in some cases, there are advantages to military commissions. There is greater flexibility to admit hearsay evidence. Confessions can be introduced in military commissions even if Miranda warnings were not issued, but they have to be reliable and, except in limited circumstances, voluntary. Though others, such as former Assistant Attorney General for National Security David Criss, have spoken eloquently about the relative merits of both systems, the advantages of our federal courts often go underappreciated. Our federal courts have a significantly broader scope, a substantially longer list of offenses can be leveraged to prosecute terrorists regardless of the terrorist organization they belong to. Federal courts provide clarity and predictability. Decades of experience prosecuting terrorists in this system allow us to predict with a greater degree of certainty the admissibility of evidence or the likely outcome. Federal courts provide a greater degree of finality as well. The results of successful prosecutions are more sustainable because of the validity of the offenses, and the system as a whole are less susceptible to legal challenge. Finally, federal courts facilitate cooperation with our partners in bringing terrorists to justice. Some of our most important allies will not hand over terrorists or the evidence needed to convict them unless we commit to only using it in our federal courts. Because of the reforms passed by Congress, we succeeded in bringing the military commission system in line with the rule of law and with our values. Today, both systems, the federal courts and military commissions, can be used to disrupt terrorist plots and activities, to gather intelligence, and to incapacitate them through prosecution. But we must let the facts and circumstances of each case determine which tool we use. That is the only way to ensure we achieve the results that best serves the safety and security of the American people. As a former career intelligence professional, I understand the value of intelligence. And when it comes to protecting the American people from Al-Qaeda and its adherents and other terrorist organizations, intelligence is critical to identifying and disrupting their plots, as well as dismantling their network. One of our greatest sources of information about Al-Qaeda, its plans and its intentions, has been the members of the network who have been taken into custody by the United States and our partners overseas. Wherever possible, we must maintain a preference to take custody of terrorists, to preserve the opportunity to elicit information that is vital to the safety and security of the American people. Those who suggest that this administration has shied away from detention ignore the fact that for a variety of reasons, reliance upon U.S. detention for individuals apprehended outside of Afghanistan and Iraq began declining precipitously years before this administration came into office. After 10 years of relentless pressure, our adversaries have become adept at avoiding areas where they are susceptible to capture, and into places where the ability of the U.S. to capture and detain them is limited. Arguing that the decline in military detention or detention by the CIA has resulted in a decline in intelligence also ignores the vital intelligence we gain from individuals who are in the criminal justice system. In the past 2 years alone, our criminal justice system has proven to be an extremely valuable intelligence collection tool. We have successfully interrogated several terrorism suspects who were taken into law enforcement custody and prosecuted, including Faisal Shahzad, Najibullah Azazi, David Headley, and many others. Perhaps no single case has generated as much controversy as that of Umar Farouk Abdulmutallab, who was charged with attempting to blow up that plane over Detroit on December Day in 2009. Now, I know that many argue that he should have been placed in military custody and that he should have never been given his Miranda rights. But the plain fact is that his arrest ultimately produced valuable information, and there's no reason whatsoever to believe that placing him in military custody would have produced a better result from an intelligence collection perspective, or would have done so more quickly. The flexibility and leverage that the criminal justice system provides to gather intelligence before and after an arrest through proffers and plea agreements, and in some cases even after conviction or sentencing, is undeniable. So we have sought to empower our counterterrorism professionals to leverage the strengths of this system to gather critical intelligence. And where appropriate, we have made adjustments to enhance our ability to collect intelligence through interrogation. Consistent with our laws and values, the President unequivocally banned torture and other abusive interrogation techniques, categorically rejecting false assertions that these are the most effective means of interrogation. They are not. The President approved the creation of a high-value detainee interrogation group, known as the HIG, to integrate the most critical resources from across the government: experienced interrogators, subject matter experts, intelligence analysts, and linguists, to conduct or assist in the interrogation of those terrorists, both at home and overseas, with the greatest intelligence value. Through the HIG, we bring together the capabilities that are essential to effective interrogation and have the ability to mobilize them quickly and in a coordinated fashion. Some suggest getting terrorists to talk is as simple as withholding Miranda warnings. Assertions that Miranda warnings are inconsistent with intelligence collection ignores decades of experience to the contrary. Miranda warnings have not proven to be an impediment in most cases. Though some have refused to provide information in the criminal justice system, the same can be said of many held in military or intelligence custody from Afghanistan to Guantanamo. But Miranda warnings have in many cases been absolutely essential to our ability to keep dangerous individuals off the streets, as post-Miranda admissions have led to successful prosecutions and long-term sentences. Rather than succumb to this false choice between intelligence collection and a successful disposition for the individual, we must make informed decisions based on the evidence and circumstances of each case to maximize our intelligence collection and our ability to keep dangerous individuals behind bars. Where our laws provide flexibility, we must empower our counterterrorism professionals to leverage it. The Supreme Court has recognized an exception to Miranda, allowing statements to be omitted if they are prompted by concerns about public safety. Applying that exception ruling to the more complex and diverse threat of international terrorism can be complicated, but our law enforcement officers deserve clarity. And that is why, at the end of 2010, the FBI provided guidance to agents on the use of the public safety exception to Miranda, explaining how it should apply in terrorism cases. The FBI has acknowledged that this exception was utilized last year, including during the questioning of Abdul Muttalib and Faisal Shahzad. When the immediate threat to public safety was addressed, Miranda warnings were provided, and as the public now knows, intelligence collection did not end. It continued. The evolution that began following the 9/11 attacks continues. Where possible, we should develop more effective and flexible tools or strengthen the ones we have to empower our counterterrorism professionals to succeed, while upholding the values and freedoms that make this country great. Combating terrorism requires a practical, flexible, results-driven approach that is consistent with our laws and our values. It is essential to our effectiveness as well as our ability to sustain that strategy over time. Our criminal justice system, even though it is just one tool in this fight, embodies each of these things. Where it is available, it is quite simply one of the very best counterterrorism tools we have to disrupt, dismantle, and defeat terrorists and their plots. It has demonstrated unrivaled effectiveness, unquestioned legitimacy, and the flexibility to preserve and protect the full spectrum of our national security objectives. A rigid approach to the custody, questioning, and prosecution of terrorist suspects, in contrast, would be ineffective, unnecessarily complicating our efforts to counter the complex and diverse threat from al-Qaeda and terrorist groups throughout the world, which would put at risk the security of the American people. The executive branch, regardless of the administration in power, needs the flexibility to make well-informed decisions about how to handle terrorist suspects based on the unique circumstances and facts of each case. A one-size-fits-all policy simply will not work. To achieve and maintain the appropriate balance, Congress and the executive branch have to work together. There have been and will continue to be many opportunities to do so in a way that strengthens our ability to defeat al-Qaeda and its adherents. As we do so, the Obama administration will be guided by the principles I have laid out here today. And finally, and as we meet here today, a process of political transformation is underway in many parts of the Middle East, an area that I have focused on throughout most of my professional career. But even as I watch history being made in the Middle East, with the political landscape being changed in ways that were difficult to imagine just 2 or 3 months ago, I am mindful of how fortunate we are to live in a society where respect for rule of law and a set of universal rights and freedoms is the norm. And I also am truly inspired by the determination and courage of those who pursue one of the most basic of those universal rights, the right to live in a society that respects the rule of law. If we have learned anything about ourselves and about our values in the period since 9/11, it is that respect for the rule of law is not something to be called upon only when it is easy or convenient. Rather, it is the very hallmark of our democracy and our social compact as a nation. I believe that we operate outside that framework and code at our own peril, and I am proud to represent a president, an administration, and a nation that feels the same way. Thank you very much, and I'll take your questions.
Mr. Brennan?
Yes.
Evan Perez, Wall Street Journal. Part of your remarks sounded like a very strong defense for trying the 9/11 accused at the federal courthouse down the street. And at the same time, you mentioned the changes that have been made to the military commissions. Could you perhaps clarify where the administration stands on those trials? And also, secondly, if you could address some of the changes to Miranda that any discussions you've had about changing the public safety exception.
On the first question about the thrust of my remarks, it was I think, a forceful defense of the utility of Article III courts for the prosecution of terrorist suspects. And I want to make sure that people understand that our decision to go forward with military commissions is part of this framework of prosecution of individuals who are charged with terrorism-related crimes. It is up to, certainly, the Attorney General and to the Department of Justice to make those determinations of where individuals should be tried and how that will be done and when it will be done. My remarks, though, were on the issue of Article III being a time-tested venue for the prosecution of terrorist suspects. On the second point, which was Miranda. Yeah, as I said, guidance went out to the FBI in December of last year to ensure that the agents and those law enforcement officers who in the first instance may confront an individual suspected of engaging in terrorist activities understand how the quarrels exception to Miranda should be used and can be used, because what we're trying to do is to make sure that those law enforcement officials take the appropriate steps to protect the security and safety of the American people. And in the first instance, if confronted by an individual such as Abdul Muttalib, what you want to do is to acquire whatever information might be available to them that would give those agents, those U.S. government law enforcement officials, the ability to then mitigate whatever type of immediate threat there might be. We've had discussions, obviously, with the Congress. They are interested in making sure that we're able to utilize the full set of tools that are available, and Miranda is one of them. But this is something that we feel can be adhered to, but at the same time, the quarrels exception gives those law enforcement officers and others the opportunity to do what they need to do in the immediate aftermath of detaining an individual.
This is Raha Walla with Human Rights First. Thanks for your comments. You alluded to in your comments the idea that a one-size-fits-all approach is not effective for countering terrorism. As I'm sure you know, on the Hill, there's been some bills introduced that would, if implemented, basically force terrorism suspects into military custody. And in the case of one of the bills, pretty much require that terrorism suspects be tried in military commissions. Can you explain for the folks in the room and individuals watching how those bills, and in particular those provisions, can have a deleterious effect on national security and undermine the administration's ability to combat terrorism?
Well, as I think I tried to note in my remarks, our criminal justice system has had a tremendous experience in dealing with terrorism cases. There is a lot of case law that has been built up. There are a lot of successful prosecutions that have been done. What we need to do is to ensure that we don't take away one of those tools that have helped keep this country safe. And the lawmaking process is still ongoing as far as those bills and those discussions. The administration policy at this point, and will continue to be, that Article III courts, the criminal justice system, is an essential tool, not just a nice tool to have, but it is an absolutely essential tool so that we can take the appropriate steps with individuals, whether they be captured overseas, and definitely if they're arrested here in the United States, that we need to make sure that we take full advantage of those tools and capabilities that are available to us. And this is something that I know President Obama feels strongly about. Military commissions are an appropriate venue for certain cases, certain circumstances, but it should not be the only one.
Mr. Brennan, thanks again for your time and your comments today. My question has to do with the relationship between law enforcement and local communities. You talked about how law enforcement are increasing their capacity with respect to intelligence gathering. And while that's been happening on a community level, we've seen law enforcement engaging in intelligence gathering tactics that have affected particular communities. I'm speaking particularly of the Muslim community, not just here in New York, but across the nation. And as we've seen the increased use of those intelligence gathering tactics, we've seen an undermine in the relationship of trust between local communities and their local law enforcement and their perspectives towards federal law enforcement. Now, you noted that the increase in intelligence gathering tactics is within the confines of the law, but unfortunately, even if something is legal, that doesn't mean that it can't undermine the trust between law enforcement and local communities. And that trust, as many law enforcement individuals have cited, is vital to countering extremism. So I'm wondering if you can share some thoughts on what have been some positive steps that experts such as yourself or the administration has been able to take to maintain that trust between law enforcement and local communities, and what more can we be doing?
I totally agree with you that trust is critical. If we're going to operate as the nation that I think we want to be, remain to be, we need to make sure that the government and its citizens are able to interact on a regular basis on these issues. That's the type of engagement with the local communities, what the FBI, Department of Justice, and others are doing. Last weekend, Dennis McDonough, the Deputy National Security Advisor, met in Northern Virginia with a large gathering of individuals from the Muslim community to explain what we are trying to do to engage and to make sure that the Muslim community does not feel as though the government is singling them out, despite some of the hyperbolic rhetoric that is out there. What we need to do is to make sure that those lines of communication stay strong. I know that FBI Director Mueller feels very strongly about this, as does the Attorney General, Secretary Napolitano, and others. There is, I think, a constant effort to outreach, but it cannot just be, obviously, the federal level. It is the state and local communities. And I think, you know, in the aftermath of 9/11, we've learned a lot of lessons, and I think we need to continue to engage and to make sure that that engagement is an informed engagement and is not based on uninformed allegations and preconceived notions about what certain groups or certain religious people are trying to do. And that's why the FBI needs to be very careful, and they are increasingly, I think, careful to make sure that they're able to leverage their intelligence responsibilities in a manner that is not intrusive, respects the privacy of individuals, is consistent with our law, but also does not harm that trust that we need to build up. Because if that trust is harmed, it can have devastating consequences as far as the relationship between people and government.
I'm sorry, I didn't introduce myself. Asim Rahman with the Muslim Bar Association of New York. Thank you.
And if folks could introduce themselves.
Lloyd Grove with Newsweek and the Daily Beast. Following on to what you just said, you began your remarks by saying targeting groups on the basis of religion, ethnicity, et cetera, is un-American. And I'm wondering, since you associated your remarks with Mr. Thompson's, whether you were referring specifically to the hearings last week in the Homeland Security Committee. And also, I'd like to know how we rank, since you spent a lot of your remarks on al-Qaeda and its adherents, how we rank those people in terms of the domestic terrorist threat and with other groups?
One of the hallmark attributes of our country is the right to speak freely and openly about issues. And I think Congressman Thompson addressed eloquently how that hearing enabled individuals to speak on all sides of the spectrum. And I think that what came out of those hearings were a lot of comments, some that were informed and some that I think were particularly poignant as far as the feelings of individuals within communities who have the perception as well as sometimes the reality of being singled out. And I do think it's healthy to air these issues, but I think it needs to be done in an appropriate manner with respect for those individuals and those groups. And the
how would you rank
Al-Qaeda?
In terms of domestic?
Al-Qaeda is still determined to carry out a strategic attack against the United States. We know that they're trying to have the ability to penetrate our defenses and conduct an attack that would have grave and major consequences on our country in terms of loss of life and damage to our economy. That is something that we need to continue to maintain our vigilance against. At the same time, there are a range of terrorist groups and individuals who are trying to take out attacks, take the opportunity to carry out attacks. That's why I said the threat is diversifying. So you have those organizations that have a worldwide network and are continuing to try to prosecute these plots. At the same time, you have individuals who may be inspired by Al-Qaeda, they may be inspired by right-wing extremist groups trying to carry out certain types of attacks. We've seen evidence of that in the United States, and that's why the intelligence and law enforcement community need to be prepared to deal and try to preempt the most strategic type of attack as well as those individual and tactical attacks.
But you wouldn't rank them in terms of domestic?
It's hard, it's very difficult to rank. I mean, in some places, in some areas of the country where we feel as though it's not an Al-Qaeda type of terrorist plotting, it's much more, it's very different than that. It may be a right-wing extremist group. A lot of resources dedicated to that, and so therefore that has primacy as well it should. And from a national level, what we try to do is to make sure we allocate resources according to the various threats that are out there.
We have time for 2 more questions for the director.
Hi, John. Suzanne Spalding with Bingham McCutcheon. I want to thank you, too, for your very strong and important defense of the use of Article III courts and our criminal justice system. It's very important, so thank you for that. I wanted to pick up at the very end of your talk. You referenced what's going on in the Middle East today and both the upheaval and the opportunity for transformation. It seems to me that we're losing, if we haven't lost, the consensus about the importance of closing Guantanamo. And you've spoken in the past and a bit today about the importance in terms of as a recruitment tool. But I wonder if, given your experience in that region and your many visits and discussions, whether you can also talk about the potential impact of closing Guantanamo at this moment when there is an opportunity for transformation in the Middle East, and a lot of eyes in that next generation are now focused in an intense way, in a different way, on the United States as a possible model and leader in some of these activities, and why there might be a special urgency. And secondly, whether the FBI guidance on the public safety exemption could be made public, and if not, why not? Thank you.
Okay, on the first issue of Guantanamo closing and what's going on in the Middle East right now, I think one of the things that is most notable about what's going on in the Middle East is that Al-Qaeda has not been anywhere near the forefront of any of these activities. It is a populist, mainly secular-driven phenomenon that continues to be seen in countries throughout the region there. Closing Guantanamo, I think, is important for our national security interests, irrespective of what's going on in the Middle East. It just needs to happen. But there are many, many complex elements to Guantanamo that truly are going to make it very difficult to move swiftly with the closing of that facility, to include those bars that the Congress has put on our ability to bring individuals here to the United States for prosecution, detention. So we're going to have to work through a number of issues. We're also working through a number of issues as far as sending individuals back to the countries of origin or to third countries. Point out Yemen is a country that I've dealt with quite a bit, and we've been concerned about sending individuals back there in light of the continuing turbulence and the al-Qaeda threat. And I must say that the very disturbing press reports today coming out of Yemen, where the government forces are reputed to have fired on protesters with several dozen dead. And I've talked to President Saleh many times in the past couple of weeks, and I'm going to call him today. We condemn in the strongest terms the use of force against peaceful protesters, and we call for further investigation of what is going on there. There must be a stop to that violence, because it's only going to feed the forces of extremism and will be very detrimental to our long-term interests in that area. So, I mean, this is something that we're watching very, very carefully. But I think the point about what's going on in the Middle East right now, we have to keep in mind. You know, we've called for governments to repeal their emergency laws. Algeria has done just that. Other countries were calling for the same thing. And so as we continue to pursue our efforts with terrorism, we need to be mindful that as we're insisting upon the adherence of rule of law in countries that are going through this political reform, we need to remember what we mean by rule of law and adherence to it here in this country. Yes.
Thank you. I want to echo the thanks for the very strong statement of commitment to exclusive use of Article 3 courts for people seized in this country, and ask about the distinction that critics of administration policy would make between that policy applied to individuals sent here, arrested here to carry out attacks on behalf of al-Qaeda, and individuals who are currently in Guantanamo, having been captured in Afghanistan or elsewhere and being held under law of war, military detention without charge. And I know you outlined some of the intelligence benefits of an Article 3 criminal prosecution of people seized here, but I'm wondering whether or not the administration's commitment is also founded in a view of constitutional and legal principles that would require that kind of approach for people seized in the United States. Oh, I'm sorry, Kate Martin from the Center for National Security Studies.
Well, as you may know, our president has a bit of a constitutional law background and believes in these principles and the adherence to those constitutional principles and our values very, very strongly. And as he is the one who needs to make many of these decisions about how to deal with terrorists, whether they be overseas, whether they be found and arrested here in the United States, I think constantly he looks at that through the prism of the Constitution and our values as a people, and wants to make sure that we're making the appropriate decisions accordingly. And therefore, when we look at the situation here in the United States, even if somebody is sent from al-Qaeda, like in Abdul Muttalib, we still believe that we need to make sure that we are able to apply our laws, apply our policies and our practices that we would if somebody was here and was plotting against us on behalf of or inspired from. So there are theaters of military operations. There are specific arrangements and policies and practices applied there. But what we need to do is to make sure that that rule of law framework and that constitutional base and those values that the president has continuously articulated in his speeches needs to govern how we deal with it. And so we are looking forward to engaging with Congress. We want to make sure that we're able to work with them because there needs to be a statutory framework that allows us to deal effectively with the challenges that we face today. But what we can't do is to just out of a certain ideology or a preconceived notion of the way to go, ignore or rule out other opportunities that have proven over the years to be a very, very effective means of not just detaining, questioning, and prosecuting individuals, but keeping this country safe.
Director, do you have time for one more?
Sure, I do.
Thank you so much. Thank you, yes. Hello, Mr. Brennan, Tamara at Fox News. Just a quick question. The administration has said that the military commissions are going forward, but 3 military lawyers for the 9/11 suspects have said their case is stalled, that the Defense Department is throwing up blocks that are cutting the funding and limiting their communication to their clients. Who's directing this, and is this coming from the White House?
I am not aware of those allegations at all. I just know that in the discussions that have been held in the Department of Defense and Justice and in the interagency, there was strong consensus that we need to move forward with the reform military commissions. We cannot hold that hostage to some of the impediments that are put in place as far as Article 3 prosecutions of individuals in Guantanamo, justice needs to be served. And we want to make sure that justice can be served for those who we believe can be prosecuted in either one of those venues. So again, I don't know what those allegations are. I just know that there's a strong commitment from Secretary Gates, the Attorney General, and others throughout the government to make sure that we're able to move as quickly as we can, respecting the rights and individuals of the rights of those individuals in Guantanamo, but justice needs to be served. This city in particular deserves to have justice for what was wrought upon this country and this city in 2001. And the longer we delay that, the longer the people, the victims, the families are going to feel that it is incomplete in terms of addressing that period of our history.
Thank you.
Thank you.
Thank you so much, Director Brennan. We appreciate your being here. We appreciate the thoroughness and thoughtfulness of your remarks. We are going to take a brief break before the panel begins. There are restrooms here. They require a code unencrypted. It's listed on the door. And please help yourself to refreshments, and we'll be back here in 5 minutes. Thank you so much.